1. Introduction. The sale of goods is an area of contract law. So if you're already familiar with general contract law rules, you will find this topic very easy. The main statutory source of law governing sale of goods transaction will always be the most recent Sale of Goods Act, which is currently the 1979 version of that act. 2. Historical background. The first statute on the sale of goods was adopted in 1893. It was changed significantly in 1979 to form the current version in force today. There have been a number of important amendments to the 1979 version, such as the replacement of the merchantable quality test with a satisfactory quality test, but it is, at its core, the same as the original 1979 version. 3. Statutory interpretation. I. Fundamental rules. Before embarking on the Sale of Goods Act itself, it is worth remembering that in English law, statutes are interpreted in accordance with the natural meaning of the words used. A quote from Bank of England and Vagliano Bros 1891 puts it best. The proper course is in the first instance to examine the language of the statute and to ask what is its natural meaning, uninfluenced by any considerations derived from the previous state of the law. It is not to start with inquiring how the law previously stood and then, assuming that it was probably intended to leave it unaltered, to see if the words of the enactment will bear an interpretation in conformity with this view. However, there are circumstances where knowledge of the previous state of the law is relied upon for interpretation, and the quote goes on to list 2 of them. The first is where it is uncertain what the significance or meaning of a provision actually is, i.e. where it has doubtful import, as the quote says. The second is where certain words had acquired a technical definition under previous provisions, and these well-known technical definitions need to be kept in mind when we're looking at the new statute. And there is a third set of circumstances where knowledge of the previous state of the law is relied upon, which wasn't mentioned in the quote but is obviously very valid. So that's where, naturally, if the statute is completely silent on an issue, we must look to prior case law to inform us where it can. So here is the full quote, setting out those 2 circumstances in rather antiquated language. I am, of course, far from asserting that resort may never be had to the previous state of the law for the purposes of aiding in the construction of the provisions of the code. If, for example, a provision be of doubtful import, such resort would be perfectly legitimate. Or again, if in a code words be found which have previously acquired a technical meaning or been used in a sense other than their ordinary one, the same interpretation might well be put upon them in the code. So keep these circumstances in mind when we start looking at the Sale of Goods Act 1979, because although the Act is quite comprehensive, in cases of doubtful imports or technical definitions, it becomes very important to look to the old case law. 4. Lex Mercatoria. Sale of Goods Act 1979, Section 62.2. One needs to know the law merchant to fully understand the law on the sale of goods. Section 62.2 reads, the rules of the common law, including the law merchant, apply to contracts for the sale of goods, except insofar as they are inconsistent with the provisions of this Act, and in particular the rules relating to the law of principal and agent and the effect of fraud, misinterpretation, duress or coercion, mistake or other invalidating cause. To be clear, the law merchant, or lex mercatoria, is the totality of unwritten usages and customs that business people regard as binding. So Section 62.2 leaves no doubt that these laws are still applicable insofar as they do not contradict the Sale of Goods Act. 5. Freedom of contract. Cardinal principle of the contract of sales is freedom of contract. The parties decide what rights, duties and risks they will each undertake under a contract. This is encapsulated in Section 55.1 Sale of Goods Act 1979, which states that where a right, duty or liability would arise under a contract of sale of goods by implication of law, it may, subject to the Unfair Contract Terms Act 1977, be negatived or varied by express agreement or by the course of dealings between the parties or by such usage as binds both parties to the contract. The point here is that even if something, a term, a liability, a duty, is implied into a contract between some parties, if there is an express agreement, course of dealings or a usage between the parties that say otherwise to the implied term, then that term won't be implied at all. This is an extremely important point in exam questions and in the real world, because just as you thought one party was the absolute mercy of one of these implied terms from the Sale of Goods Act, that party can then provide evidence saying, well, actually we had an agreement or we had a course of dealings that said otherwise to this implied term, and just get away scot-free. So very important to keep that in mind. 6. What is a contract for the sale of goods? Section 2.1 explains that a contract of sale of goods is a contract by which the seller transfers or agrees to transfer the property and goods to the buyer for a money consideration called the price. Section 61.1 emphasizes that a contract of sale includes an immediate sale, but also an agreement to sell at a future date. Thus, there is a distinction made here between the outright transfer of property and goods after payment and specifying a future date or condition for transfer of property to occur. And lastly, Section 2.6 explains that an agreement to sell becomes a sale when the time elapses or the conditions are fulfilled subject to which the property and the goods is to be transferred. So to be absolutely clear, an agreement to sell at a future date does fall under the Sale of Goods Act. It is a contract for the sale of goods nevertheless. 7. Significance of sale versus agreement to sell. Remedies. So as just stated, there is a distinction between an outright sale of something and having an agreement to sell that something, and the distinction here leads to a difference in treatment. So this is something that your examiners will try and trick you with. The first distinction revolves around the action for the price of the goods. So the only remedy for a breach of an agreement to sell is damages for breach of contract. So that's the only remedy you can get for breach of an agreement to sell. Very simple. And likewise, for the breach of a contract of sale, damages are also available, but many other remedies are as well. So for example, an action for the price of goods is available for the breach of a contract of sale where property has already passed to the buyer. And section 49.1 reads, where under a contract of sale, the property and the goods has passed to the buyer and he wrongfully neglects or refuses to pay for the goods according to the terms of the contract, the seller may maintain an action against him for the price of the goods. The clear wording of section 49.1 seemingly leaves no room for maintaining an action for the price of the goods without property first passing to the buyer, but the very recent Supreme Court decision of PST Energy 7 Shipping LLC and OW Bunker Malta, more frequently just referred to as the Bunker case, 2016, casts doubt on this. And another distinction is in remedies and tort. So, if property has passed, the buyer becomes owner of the goods and so also has remedies in torts for wrongful interference with his goods against the seller or a third party. And the last distinction revolves around risk of loss and damage. So, the Act makes it clear that the risk of loss or damage to the goods lies with the owner of the goods. Thus, in an agreement to sell, it is still the seller who bears the risk since property has not passed and can't pass. He still owns the goods until, the date comes or the condition comes where property does pass. So likewise, once property has passed, the buyer becomes the risk bearer. The whole difference in treatment here revolves around the fact that where you have an agreement to sell at a future date, property can't pass. So you can't have all of these things such as remedies in tort, the risk of loss and damage passing, or this action for the price of the goods remedy. 8. The Hughes and Pendragon case. There was an agreement for a car dealer to sell a particular car to a buyer. Let's call him B. The agreement was silent about the price of the car and any potential delivery date. There was an assurance by the dealer that, if a manufacturer allocates one of these rare cars to his dealership, B would be the first buyer in the queue to buy it since he was the first one to pay a deposit. Such a car was allocated to the dealer, but he sold it to someone other than B. Then of course, B claims specific performance or alternatively, damages for breach of contract. It was held at first instance that there was no vehicle, there was no price, there was no delivery date. I am entirely satisfied that the payment of the deposit was no more than an agreement to agree, and that is unenforceable. However, it was held at Court of Appeal that under the Sale of Goods Act 1979 there can be an arrangement to sell what are called future goods, which include goods to be acquired by the seller after the making of the contract of sale, and there can be a contract for the sale of goods, the acquisition of which by the seller depends on a contingency, a condition that is, which may or may not happen. Sections 5.1 and 2. That there was no vehicle at the time of any arrangement to sell, and that Pendragon might not be allocated one, were not fatal therefore to the existence of a contract. So the Court of Appeal basically overturned the judgment at first instance and awarded B damages for breach of contract. The provisions seem to relate so perfectly to the facts of Pendragon that one wonders how the lawyers and judge missed the application of them in the first instance. Section 5 reads, 1. The goods which form the subject of a contract of sale may be manufactured or acquired by the seller after the making of the contract of sale in this act called future goods. Section 2. There may be a contract for the sale of goods, the acquisition of which by the seller depends on a contingency which may or may not happen. And subsection 3. Where by a contract of sale the seller purports to effect a present sale of future goods, the contract operates as an agreement to sell the goods. It should be noted here that the distinction between a sale and an agreement to sell is further refined under Section 5, with Section 5.2 clearly stating that an agreement to sell existing goods, depending on a contingency, is treated as a sale and not an agreement to sell. Meanwhile, Section 5.3 states that a sale of future goods is to be treated as an agreement to sell and not simply a sale like existing goods are treated in section 5.2. Just to recap, if what is driving the contract is a condition like in Pendragon, then that is a sale of goods, but if what is driving the contract is a date, then that is an agreement to sell. So the way the law looks at what happened in Pendragon is that when the car dealer received the car, the transfer of ownership happened immediately, and therefore the buyer already owned the goods and so was entitled to a remedy when the car dealer sold the goods on to somebody else. An exam might well test to see if you realise that had the situation been the same, except when the car dealer received the goods then were subsequently damaged, that actually it would be the buyer that would suffer the losses for that damage, because it would be the buyer who had the ownership, since ownership would already have transferred as soon as the condition had been met. And of course that's something that can come up in an exam very easily, since Pendragon shows the benefits to the buyer of that ownership transferring to him as soon as the condition is fulfilled, but it doesn't show the downfall, which is that any risk and loss that comes to the goods after transfer has occurred will be on that buyer. 9. PST Energy and OW Bunker 2015. So this case is a very complicated one because it is about this long chain of buyers and sellers in oil, but I've tried to simplify it as much as possible while maintaining the main point of it. So OW Bunker supplied gas oil known as bunkers to the buyers, who we will again call B. The contract between them stated that payment was to be made within 60 days after delivery. This is known as a sale on credit because payment was not immediate. The contract included a retention of title clause stating that property in the oil does not pass to the buyer until the price was paid in full. The contract did allow for B to consume the goods for the purpose of fueling their vessels, as this was of course very important. B did consume the oil shortly after receiving it and never paid OW Bunkers. OW Bunkers became bankrupt and sued B for not paying by the 60-day period. The reason why B never paid OW Bunkers was because they knew that OW Bunkers went bankrupt and failed to pay its own suppliers, Rosneft, for that oil. Since Rosneft also had a retention of title clause in their contract of OW Bunkers, and since they were also never paid, Rosneft also had a claim against B for the price of the goods. So B worried that if they did pay OW Bunkers, then Rosneft would sue them for the price of the oil as well, and they would also end up paying for the oil effectively twice. So B argued that 1. The contract between them and OW Bunker was a sale of goods, and so the Sale of Goods Act 1979 applied. And 2. In order for OW Bunkers to successfully claim the price of the goods under section 49.1, property would have had to have passed already to B, but due to the retention of title clause, this was not the case. So it was held in the Supreme Court that this was not in fact a contract for the sale of goods at all, and thus section 49.1 did not apply. Annoyingly, the Supreme Court refrained from categorizing this type of contract, other than referring it to as sui generis, unique. Not very helpful at all. The court simply stated that because the seller retained title to the goods while at the same time allowing the buyer to consume them without paying anything, it could not be a sale of goods. And Laurence Mance said, in its essential nature, it offered a feature quite different from a contract of sale of goods. The liberty to consume all or any part of the bunkers supplied without acquiring property in them or having paid for them. The obligation on the part of OW Bunkers to be able to pass the property in respect of any bunkers not so consumed against payment of the price for all the bunkers cannot make the agreement as a whole a contract of sale. And a big criticism of this is that this ruling does not take into account the commercial consequences that follow from it. So as it stands, parties like B in OW Bunkers actually do risk paying twice or even more for the same goods, and this level of risk is inherently very unfair.